In Folsom versus Rowell, a father wrote a will that he hoped would persuade one of his kids to care for their disabled sister. After she died decades later, various heirs got into an argument over what should happen to the remainder. Howard Folsom's youngest child, Alma, was intellectually disabled. When Howard died in 1960, he left Alma a life estate and all his property. His will left the remainder of the estate to whichever of his other 5 children took care of Alma during her life. If none of the children took care of Alma, the property was to go to whoever did look after her. Alma lived with her sister Lillian Rowell and Lillian's children from 1960 to 1973. Then Alma moved in with Mitchell Folsom, the widow of one of Alma's brothers. In 1994, Alma suffered a stroke and went to live with Linda Smith, one of Howard's granddaughters. Linda and Mitchell shared Alma's care for the next several years. Howard's grandsons, the Folsom heirs, performed maintenance on the house but didn't live with Alma. Alma died in 2001. Lillian and Mitchell had also died by this time. The various heirs got into a dispute about the final disposition of Howard's estate. Under state law in 1960, which applied to this case, a vested remainder interest could be passed to the remainderman's heir, while a contingent interest couldn't. Lillian's children, the Rowell heirs, claimed that the remainder interest had vested in Lillian when she took in Alma in 1960. The Folsom heirs argued that the remainder interest created by the will was a condition precedent that couldn't vest in anyone until the termination of the life estate on Alma's death. The Superior Court concluded that the remainder interest in Howard's estate was initially contingent, but it had vested when Lillian took Alma into her home. This interest wasn't contingent on Lillian's surviving Alma and could therefore pass to her heirs when Alma died. The court also concluded that the remainder interest of anyone who wasn't one of Howard's children could no longer vest once any of the children provided care, and that the term children didn't include grandchildren. The court held that, under the terms of the will, only the heirs of Lillian Rowell could take property. The Folsom heirs and Linda Smith appealed to the Georgia Supreme Court.